Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Now we are dealing with a case of abetment to commit suicide. In this case, the important points are: number one, not allowing the daughter-in-law to watch TV. Not allowing her to watch TV is not abetment to commit, is not cruelty. Not allowing her to meet the neighbours. Women normally after a day's work or after the so-called cooking is over, you may be seeing in the villages particularly, this woman and the neighboring woman, they used to stand near the compound gate and they will be chit-chatting with each other. She was not allowed to meet the neighbours, not cruelty. She was not allowed to go to the temple alone. It's not cruelty. She was made to sleep on the, not on the cot, on the carpet. It's not cruelty. And she died because of these reasons. So the husband and in-laws were made as accused under section 306 IPC, that is the 498A. But the Honorable High Court, Bombay High Court, Aurangabad bench, held it is not cruelty, held it is not abetment to suicide, and ultimately allowed the appeal. The case is XXX versus the state of Maharashtra in criminal appeal number 258 by 2004, dated 17/10/2024. Right. So, to know the facts, the marriage took place on 24/12/2002. The marriage was solemnized on 24/12/2002. After 2 months itself, she started alleging harassment and ill treatment, repeated ill treatment in the house of the in-laws. Actually, the Holi came on 23/3/2003, and at that time, the in-laws went to the house of this particular woman and asked the son-in-law to send her. Ayya, ma ammayini pampichante. And he said, if she goes away, who is going to prepare meals for me? They came back. So, and she was not allowed TV, all these not allowed TV, not to meet the neighbors, and not to go to the temple alone, and making her sleep on the carpet. And another allegation is that she was asked to draw water, to fetch water at about 1 a.m. or 2 a.m. in the midnight. Of course, we have got the experience because the municipal tap water will come around 3:30 a.m., 1 a.m. Of course, nowadays they are coming in the daytime. So likewise, at that time, she was forced to wake up and get the water. And even though she was suffering from typhoid, she was asked to the domestic course or domestic work. Of course, there may be some below medium poverty line people. She was harassed like that. Ultimately, unable to bear the harassment, on 1/5/2013, she committed suicide by hanging. Of course, there was also some misunderstanding between the parents of the deceased woman, that these people said informed the parents that she died due to electrocution, but after coming to know that she died due to hanging, they were under the impression that because of the harassment meted out the in-laws, she committed suicide. Therefore, the police registered a case of 498A and 306 read with 34 IPC against the husband, his parents and his brother. Tukiga idi katha. Right? Then, here the point is whether not allowing her to watch the TV and other things, whether they amount to harassment, whether they amount to abetment to commit suicide or not. The Honorable High Court said certainly no. These are the classic things. These are the general incidents which happen in every middle class family. The second point, as far as evidence is concerned, These allegations are general, vague, and omnibus. Suppose if she says that she was not allowed to watch the TV, she should have stated, on so and so date, when so and so program is coming, I wanted to watch the TV, but they have not allowed. The place, the time were not specifically mentioned, therefore, no evidence was there. The humiliation will be there, humiliation in a general form. So please remember, humiliation in which form? This is not specifically mentioned, this is not specifically found. When she was suffering from typhoid, was she taken to the hospital? When was the festival? When she wanted to go to the temple? When was the auspicious occasion? That was also not mentioned. So therefore, the High Court came to the opinion that these are all general omnibus allegations. Second point, the Holi is on 23/3/2003. The date of her committing suicide is 1/5/2023. That means there is a gap of around 1.5 months. So there is so many methods of relief to her. It is not abetment to commit suicide. In middle class families, these things are quite common. So placing reliance on our very beautiful cases, State of AP versus M. Masudan Rao 2008, and also K. Subbarao versus State of Telangana 2018. Humiliation in particular form is not mentioned, therefore no evidence on that aspect. As such, the appeal is allowed and the conviction is a conviction of 3 years, I think it is set aside. This is the decision delivered by Aurangabad bench of Bombay High Court. Please read the case law and enrich your legal knowledge. Thank you.